Meanwhile, during the cross-examination of witness Tumelo Madala, the attorney for accused 1 to 4 made a damning claim. Lawyer Tshepo Thobane alleges there's a witness that will testify that Meyiwa was having an affair with Zandi, who is the sister of his then-girlfriend, Kelly Khumalo.
A witness will come and testify that Zandi, while she was staying with Kelly and Senzo in one bed, in one unit, Zandi had her own bedroom. That witness will come and tell the court that Kelly instructed Zandi to guard Senzo while she's busy with her music career issues.
Uzuza azothi uZandi wayehlala kanye nabo kule unit leyo uzoqhubeka ke asethi uKelly wabe esetshela ke uZandi leke melayela ke uZandile ukuthi agade uSenzo ngalesikhathi yena ke eqhubeka ke necareer yakhe yomusic.
Lungile ngiyakuzwa lokho, but mina bengekho lapho.
It's cool, it's okay, I hear that, but I wasn't there.
That is why ngingayazi leyo nto, because mina mangifikile ngikubonanga lokho ngaleso sikhathi. Ngingakwazi.
Hence I don't know that, because on my arrival or when I arrived I didn't see that. That is why I know nothing about it.
We're joined by legal analyst Mpumelelo Zikalala. Good evening to you. Thanks for your time. So much claims, of course, coming out of this particular case. It is important for us to remind ourselves of what the substantive matters that relate to this case are and the role that this evidence has played in speaking to some of those issues.
This is very important. Maybe if we separate the two within the two parties. We then say from the state side, it is only one objective, just to prove beyond reasonable doubt that the version that is placing to the honorable court is the only version which the court must believe, and it will do that by providing expert evidence, in which it has then done earlier, and also evidence of the people that were in the house, providing first-hand experience of what happened on that fateful night. So when they are doing that, they are trying to extract all the relevant elements pertaining to the charges which they preferred against the accused. Now, in the defense of the accused, the defense attorneys or legal representatives are then saying, we are going to plant instances of doubt, we are going to show how inconsistent the witnesses are to such an extent that the court cannot simply accept this particular explanation as the only one. And the state, which is why we'll go to town with regards to the defense, will go to town in terms of the experts, in terms of saying how they didn't provide their expertise in a particular manner, in a manner in which a reasonable expert would have done. And when it comes to witness such as the witness that we had today, it will try and show inaccuracies or certain motives of why they are lying. The state is in a bit of a back foot in this particular instance, because you then have about 3 versions which can then appear. Versions which will appear from statements which would appear in docket number 1, version that appears in docket number 2, and the third one which appears when one makes their evidence in chief during cross-examination, also on re-examination. That is good for the presiding officers, because that means that it's easier for you to extract the truth from the lies. However, it's a member task for both the parties, because they're trying to fit in all these missing pieces, while making sure that they speak to each other, they are consistent. If you are at the state, if you are the defense attorneys, you want to make sure that you are providing all you can to show the inconsistencies that are there.
Planting seeds of doubt, Mr. Zikalala, would you say that that is precisely what the defense has done today? And upon further, exploration of those doubts, what are they going to need to do to prove that these are not just claims to derail the case of the state, but that these are credible matters that the court should consider?
The first one is that if they are going to say witnesses are going to come and state the following, probably those witnesses would need to come. Either they come voluntarily or an application to subpoena them is that made to the court. So they are there and they are able to provide the evidence that or the versions which are put to the current witnesses. The second one is to then say, from the expert side, a reasonable expert witness or reasonable expert forensic investigator for example, would have collected evidence in this particular manner, and expect policemen would have provided or rendered their services in this particular manner, and we have done the total opposite. So the planting of those seeds simply means that I want to show instances of doubt, and in instances where things are not talking to each other, pertaining to what you stated earlier and what you are stating now. Let's also remember that the truth will never change regardless of whether it's written today or even 8 years ago. But what matters the most is that there can be instances of mistakes here and there, but it can't be glaring mistakes, which is why you would find the defense always going back to statements that were written and asking the questions of what did you mean, why are you changing your story now, what motivated you to change this particular story. But another one is that we must also remember that it is not the job of or the burden of the defense to prove their case. They are only there to say, we are going to deal with whatever the state is giving to us so that we are able to show that our clients are not guilty. The greater burden is then placed on the state to say, provide all the evidence that you can so that at the end of the day, you are able to provide this burden of proof, which is very high, by saying that there's no unreasonable explanation other than the one that the state is bringing to the table. It would have been wise, which is why it was also crucial for the state to then say, let us sit down with these two dockets, find where there are consistencies, find where there are clashes, and check, are these clashes so clear and just an extent that we have to regard this particular witness as a person who's lying or misleading us, or was it just an honest mistake that can be rectified during a re-examination or cross-examination?
From your own analysis of the evidence coming out of court today, would you say that there were glaring inconsistencies between the evidence given by this witness, this is based on the statement they gave to police at the time, versus the explanations and what we've heard in court?
I would say there are certain instances which they don't really tie up in terms of rationality. One would to say, remember that you've written the statements sooner after the event has occurred, so it should be fresh in your mind, all the details should be there. And what you stated then, I think we should place more reliance on it than what you are stating now, because this particular process or events happened 8 years ago, so it's easy for you to forget the minor details. But then the next question would be, if you are going to add the entering of the intruders, then run off to another room and close and stay there, it then means that at that particular point in time, while you're in that room, you don't know what happened because you are not an eyewitness at the end of the day. So your recollection of the event will only start and end up until you've exited the room, and that's where it ends. So that's the only evidence in which you're supposed to give. But at the end of the day, or maybe in addition, things or events that happen after may be able to have certain motives that the defense may come up with. We don't know as yet because we're still waiting for Africa to conduct a cross-examination. So there may other certain things that may come that can be able to prove that, in fact, what you are doing here, you are not telling the truth. In this particular arena, in this medium, you stated the following, but now you are changing. It may have been that in that particular medium, you are not under oath, so you are not obligated to tell the truth. But what motivates you to mislead members of the public, or was it a scripted show? By that I mean bringing in all the other media platforms in which this particular witness has spoken into, which is why it's important again that in instances such as these ones, the only version that you should place, or the first time in which we hear the sequence of events of what happened in that fateful night, should be inside the courtroom and not anywhere else, so that you ensure that you are consistent and you tell the truth all the time.
All right. Mpumelelo Zikalala, we'll leave it there for tonight. Thanks for your time.